Okay, good morning, everyone. This is Judge Lopez. Today is April 4th. Folks, the line is completely unmuted. I'm going to ask everyone to please keep your phone on mute unless you're addressing the court. I'm going to try to give this a chance. We're here on a scheduling conference in adversary proceedings. Let me go ahead and take appearances. Why don't I start in the courtroom?
Good morning, Your Honor. Jennifer Hardy of Wilkie Farr on behalf of the Texas plaintiffs. Also on the line, I have Ms. Kiara Cisco from Wilkie.
Okay, good morning. Good morning. Okay, Mr. Battaglia, I see you there. Good morning.
Good morning, Your Honor. Ray Battaglia for Free Speech Systems.
Okay. Does anyone else wish to make an appearance today?
Your Honor, Vicki Driver with Crow and Dunleavy on behalf of Mr. Jones. I'm also here with two of my colleagues that will be filing for a Pro Hoc Vice entrance very soon, Mr. Christopher Davis and Mr. Derek McClellan out of my Tulsa office. You may see them there on your screen, okay. And I'm here to introduce them. And if Your Honor would not mind, they have had far more to do with negotiating what will be presented to the court today. Even without the Pro Hoc, would Your Honor mind terribly if either Mr. Davis or Mr. McClellan spoke?
Absolutely not. Welcome and welcome. Okay, anyone?
Thank you, Your Honor.
Let me just start with any other party in the FSS case, and then I'll turn to the members of the Jones case.
Good morning, Your Honor. Dan Sinright from Paul Weiss for the Connecticut plaintiffs. In both cases, my colleague Martin Salvucci is also on the line and also appearing by video.
Okay. Good morning. Good morning.
Good morning, Your Honor. Ryan Chappell on behalf of the Connecticut plaintiffs as well.
Okay. Good morning. And some folks are still joining. I'm going to just ask everyone, the line is completely unmuted. There's about 26 callers, including me, on the line right now, and just asking everyone to keep their phone on mute until I think we can pull this off without having to do the 5-star stuff. Anyone else wish? Let me turn over to the Jones case. Anyone from the committee wish to make an appearance in the Jones case?
Good morning, Your Honor. David Zemsky Aiken for the Official Committee of Unsecured Creditors. The committee is not a party to the adversary. I don't anticipate having to make any comments, but the committee is available should anything arise that the court needs to hear from us.
Perfect. Thank you very much, Mr. Zemsky. Good to see you.
Good to see you, Your Honor.
Anyone else wish to make an appearance today? Okay. Who should I turn this over to?
Your Honor, I can make a couple of introductory remarks, and then I will turn it over to Mr. Sinreich at Paul Weiss.
Okay.
So, Your Honor, we're here on 2 scheduling motions in the 2 non-dischargeability adversary proceedings. Well, 4, 2 on behalf of the Texas plaintiffs, 2 on behalf of the Connecticut plaintiffs. We filed scheduling motions. We've been in discussions with the debtor, both the Texas and Connecticut plaintiffs, and I believe we have largely resolved issues with respect to the scheduling motions. Okay. And I believe Mr. Sinreich was going to outline the resolutions.
Okay. Thank you. Mr. Sinreich, I'll turn it over to you, sir.
Thank you very much, Judge, and thank you for not making me try to figure out the star 5 today. Good morning, afternoon, everyone. Dan Sinreich from Paul Weiss on behalf of the Connecticut plaintiffs. As my colleague just mentioned, we've been in contact and we've met and conferred with counsel for the debtors over the last several days. I think, although I'm sure Mr. McClellan, Mr. Davis, Mr. Battaglia will keep me honest, I think that we've reached consensus on scheduling for these summary judgment motions. The agreements with respect to Jones and FSS are different, so I'll start with the agreement with respect to Jones. With respect to Mr. Jones, we've agreed on a modified schedule that would first extend Mr. Jones's time to answer the non-dischargeability complaints, and that would also push back the summary judgment briefing schedule that we had originally proposed in our motions by about 2.5 weeks. That time will be helpful to debtors' counsel to familiarize themselves with the state court records and the state court judgments that we expect will be the subject of the summary judgment motions. So the agreed on schedule would be, and we'll follow, subject obviously to court approval, we can follow this up if everything's ironed out with a stipulation and proposed order that memorializes all of this to make life as easy as possible for Your Honor and for the clerk. The proposed schedule would be that Mr. Jones answers the complaint on April 28th, 2023, that the Sandy Hook family's summary judgment motion would be filed on or before May 12th, that Mr. Jones's opposition or response would be due on June 12th, that the Sandy Hook family's reply brief would be due on July 7th, and that obviously Your Honor will schedule a hearing if you think a hearing is appropriate at your convenience, and we would propose that the deadline to exchange exhibit lists be due approximately 1 week, or not approximately, excuse me, would be due 1 week before the scheduled summary judgment hearing if the hearing is scheduled.
Did you have a proposed week that you were thinking about for the hearing on the summary judgment?
So, Your Honor, it's summer, and I understand that folks are traveling. I wouldn't want to propose one without consulting with my colleagues and with our opposing counsel. Maybe what we can do, if it's okay with Your Honor, if it's okay with my adversaries, is we can all circle up and compare calendars and maybe propose a week or two that we think works best. Obviously, if the court has blackout dates, we'll avoid those.
I'm just reach out to my case manager when you have kind of maybe a couple of proposed dates, and let's just get one on the calendar for that. And then you can upload the step, and you've got everything there, all the dates, and I can just sign it.
Okay. We'll do, Your Honor. We'll do that before we upload the stip and proposed order.
Okay. Okay. That's Jones. What about FSS?
Sure. So with respect to FSS, there's a threshold legal issue in the FSS adversary proceeding about whether a corporate debtor proceeding under subchapter 5, like FSS, can be held liable for claims under section 523A of the Bankruptcy Code.
Mm-hmm.
It's a relatively new legal issue, a novel legal issue, and as Your Honor may be aware, there is a split of authority on this issue. The Bankruptcy Court in the Western District of Texas just issued a ruling on this issue, and then after the ruling, certified a direct appeal to the Fifth Circuit to resolve precisely this question.
Mm-hmm.
There's a petition pending in the Fifth Circuit requesting leave to pursue a direct appeal that was filed about 2 weeks ago, and our proposal would be, and the parties have agreed, subject to court approval, that we would abate the adversary proceeding with respect to FSS until 14 days after the Fifth Circuit issues an opinion on in this appeal on the question of whether a corporate debtor proceeding under subchapter 5 can be held liable for claims under section 523A of the code.
Okay. So I take it if the Fifth Circuit takes it, everything will just be abated, and we'll wait for the Fifth Circuit to rule. And if the Fifth Circuit doesn't take it, then someone will reach out and we'll figure out where things go.
Right, Your Honor. I mean, obviously, I'll defer to Mr. Battaglia on his preference with respect to his client, but I expect that what would happen is that he would file a motion to dismiss with respect to FSS on those grounds. So,
just in terms of, so for now, the FSS adversary proceeding will just, someone will upload something that just abates all the deadlines until further order of the court or something, and then someone will reach out when it's time to make sense. That's fine with me.
That's right. That's the agreement between the parties, and it sounds like it's okay with the court. So we will
100%.
Get something.
100%. And I'm familiar with the legal issue, and I know the posture of where things sit with the Fifth Circuit with respect to Judge Gargano's decision. So, got no issues with it.
Great. Your Honor, nothing else, unless Your Honor has questions, nothing else from the Connecticut plaintiffs. I think that irons out the various issues we've raised with our scheduling motions, but obviously if my colleagues, the counsel for the Texas plaintiffs or any of the debtors have something to chime in or correct any mistakes I may have made, I'm happy to turn the microphone over.
All righty. Ms. Hardy?
Thank you, Your Honor. What Mr. Sinreich described with respect to the Connecticut plaintiffs would also apply with respect to the Texas plaintiffs, so we've agreed with that.
Right.
I did also want to mention one additional thing. When both the Texas and Connecticut plaintiffs initially filed the adversary proceedings, we had contemplated consolidated adversary proceedings against FSS and Jones. Obviously, this is taking different paths, and so we have agreed to dismiss without prejudice Mr. Jones from the FSS adversary and FSS from Mr. Jones adversary proceedings, so they will proceed as two adversary proceedings with a single defendant. I think that also covers everything. Other than, of course, in the event that the court does not grant summary judgment in the Jones case, we've only agreed so far as to the schedule regarding summary judgment. Then, of course, we
think that makes sense.
Meet and confer about a subsequent schedule.
That makes perfect sense. That makes perfect sense. Thank you.
Thank you.
Okay. The schedule that the parties have proposed, it makes perfect sense. If it works for you all, I've got no issues with it, and I'll be incredibly accommodating on the dates. Just find that, a time that works. But I'm going to want to, it's an important issue, so I'm going to want to block out, essentially half an afternoon on it. I'm not saying the parties need to take the entire afternoon, but I want to make sure that everyone has as much time as they need to make whatever arguments they want, and everyone's prepared for it. So just reach out to my case manager once y'all have agreed. Let me just turn. So I guess, Mr. Battaglia, it sounds like your adversary is going to get put on ice for a while. So, Ms. Driver, I just want to confirm that y'all are okay. Oh, I should say that, or anyone here who's appearing on behalf of Mr. Jones, that these proposed dates are acceptable.
I'm going to turn this over to Mr. McClellan.
Oh, Mr. McClellan, I see you there. I found the box. Sorry about that.
Yes. No problem, Your Honor. Yes, Your Honor. Everything in regard to scheduling, everything that has been discussed today is consistent with the understanding that of the agreement that we've hammered out over the last couple of days.
Okay. All righty. So my understanding is everyone's going to reach out and get some dates and reach out to my case manager once everything is solidified, and then you'll upload whenever you upload it. Reach out to my case manager. I'll take a look at it and I'll get it signed and on the docket right away. Okay. Thanks everyone. Anything else we need to talk about today?
Nothing. Thank you, Your Honor.
Okay. Thank you. Anything else? Okay. All righty, folks. Thank you very much for your time. Just upload it and let me know. Thank you.